All right. Good afternoon, everybody. I see that everyone is starting to join us. They're starting to log in. And I am so glad that you guys are all here for us because this is our last webinar of 2024. And I honestly cannot believe it. This year has flown by, but we can't thank you enough for all of your support, for watching these webinars, for continuously helping our sponsors that have been here with us from the start, and then just for taking the time to learn something. So we're glad to have you with us. You're going to hear a lot of great information from Neil, and we've got Doug and Cash with us today. So it's going to be a good time. I definitely want you to ask questions. You can put those in the Q&A box. We'll also keep an eye on the chat box as well. But both Doug and Cash will be able to answer a lot of your questions during our breaks and then also at the end of the webinar. But you'll also meet Fox AE and HMR when we take those breaks. They're great partners of ours, and I can't wait for you to meet them. But I know that we have a lot to talk about, so I want to go ahead and get started now. And I'd like to introduce Doug, who's coming in as one of our moderators, and he'll be able to introduce Cash for us as well. But for those of you who don't know Doug, he is no stranger to being an underdog, and he's been a trial lawyer since 1985, and he has the reputation of being the lawyer's lawyer. So that means he's been trying and winning the unwinnable. And he has a passion for the courtroom. He's handled thousands of cases. He's taken hundreds of them to trial. And he's also scored some of the largest verdicts in Florida's history. He's a past president of the Florida Council of Bar Association presidents, as well as the very first recipient of the Brevard County Bar Association Professionalism Award. And I was so honored to be there when he received their Lifetime Achievement Award as well. In addition to that, he serves on the executive committee of the National Trial Lawyers. And in January, he is actually going to become the president of the National Trial Lawyers Association. And we are so honored. He's going to be a great president. And I definitely encourage you guys to just reach out to Doug. He's probably one of the most personable attorneys I have ever met in my life, one of the greatest humans. And he's right there in Melbourne, Florida. So if you get a chance to go there, please stop in and see him in his office. He would love to meet you guys. But Doug, we're very excited. This is going to be a great year for you.
Well, thank you, Ginger. Neil and Cash, getting to work with Jennifer, I just did a webinar with someone named Jennifer, but Ginger has been the face of Connectionology. Geez, Ginger, even though you appear to be quite youthful, you're a grizzled veteran. You've been doing this for a while. And maybe during our webinar at one of the breaks, you can show us our Connectionology mascot. But Ginger is fabulous. We love working with her. She's one of the most positive people I know. So, Ginger, thank you for that nice introduction. You did fail to mention that I'm a Florida notary public. That is often overlooked. Cash Sessler is from Seattle, Washington. He's a consummate trial lawyer, consummate professional, lectures throughout the country. He's on the executive committee of the National Trial Lawyers, very active in his legal community and community at large in Seattle. He'll be speaking at the summit in January, in National Trial Lawyers Summit. And so those of you who see him, he's also helps, we work together on Ethics Palooza for the National Trial Lawyers, which he just finished recording for that, and that'll be available for NTL members before the summit and during the summit. So, Cash, it's great to see you out of Seattle. What's happening out there today?
Well, it's great to be here today. I'm looking forward to Neil's talk today. I'm excited about it. I love the topic. And otherwise, just getting ready for finishing up the year and getting ready for a trial next year. That's what we're up to.
Well, Neil, let's get to it. First time I met Neil was in Harrisburg, Pennsylvania at a Connectionology seminar. And I was so impressed with Neil with his presentation there. I said, this guy's special. He is something else. And then we did another Connectionology up in Rhode Island. You remember that, Neil?
That was fun.
That, and I got to meet Neil and his wife and just great people. But Neil is tough as nails. He looks like, you look at him here, you think he's just kind of an easygoing guy. He brings it. He is tough as nails. He's been practicing for 36 years. He's board certified by the National Board of Legal Specialties certification in both civil trials and civil pretrial practice. He's multiple years, consecutive years, back to back, as one of the top 10 Pennsylvania trial lawyers. He's not afraid of the courtroom. Also, Neil is very active in seeking justice wherever he goes, as Cash and I do as well. But he's done things such as served as chair of the Senatorial Advisory Committee for the selection of United States attorneys and United States marshals for Pennsylvania. That's 3 districts, Eastern, Western, and Middle. And he currently serves for the Senatorial Advisory Panel for selection of U.S. District Court judges for the Middle District of Pennsylvania, being appointed by 2 senators, Senator Casey and Senator Fetterman. He's a frequent lecturer on trial techniques. His success rate is incredible. What he does for his clients is why we practice law. So, Neil, let's get to it, man.
Thank you. It's a pleasure to appear on a panel with guys like Doug Beam and Cash. And it's an honor. And I thank the Romano family for having us, and Ginger for everything that she does. Apparently, Doug, this is the last webinar of the year. So I'm honored to have that position, and we'll move through it. Let me tell you what this is not about. This is not about a multi-billion-dollar class action. This is not about a multi-million-dollar medical malpractice case or child sexual abuse case. This is about the grist of the mill in all of our offices. This presentation discusses moving forward, expediting, and quite honestly, bringing justice for people that have been involved in collision cases, intersectional collisions, tortfeasor, defendant, underinsured motorist carrier. And the idea came to me from a real life case earlier this year, and I ran it by John Romano and Ginger, and they suggested that we turn it into a presentation. So what we're going to talk about is using insurance company communications in prosecuting your auto cases against the national carriers. And what types of communications are we talking about? We're talking about things like claims notes, codes of conduct, correspondence, the filings that they make with the insurance commissioner, their websites, their verified pleadings. In Pennsylvania, insurance companies have to, just like every other defendant, they have to verify their answers to the complaints, and they have to verify their answers to discovery. Those are a fertile ground for examination. The Unfair Insurance Practices Act that hopefully you have in your state, and we certainly enjoy in Pennsylvania, claims manuals and insurance company procedure manuals that you may have gotten in other cases, maybe in bad faith litigation, or maybe in breach of contract litigation or coverage litigation, that have application in these auto cases. I am talking in terms of what you do with those materials at depositions. And on the screen are 4 great books about depositions. The Deposition Handbook, Mark Kozorowski's 30B6 book, Advanced Depositions by our friend Philip Miller and the late, great Paul Scopter, and of course, Rules of the Road by Rick Freeman and Patrick Malone. There are 2 that I would add to that. I would add Satch Oliver's book on depositions or trial, and all of the great tips in there. And then Mark Kozorowski has published this year the obstruction book, litigation obstruction. All of Mark's books, and these are all easily obtained and well worth the price. But Mark's books have chapters or divisions on each state. So the state that you're practicing in, he will have some cases and some tips on those states, as well as, of course, as a federal law overview. Here's the first question. Why do I need this deposition? Or as I like to put it, when I started taking insurance company representative depositions, on more than one occasion, a judge said to me, this is a quote, "Mr. O'Donnell, don't you have enough to do? And why do you need this deposition?" Or one other judge said to me, "Why is no one else asking for these? Why is nobody else fighting about this?" So we've been doing this for well more than a decade, as you'll see from some of these clips. But I think the reason you need this deposition is to focus the case, to focus it on the people that are making the decisions on whether they're going to pay our clients or whether they're going to ignore our clients. And you can be rest assured about this. The person that's trying to take their depositions, he gets their attention. She gets their attention. When you're dragging them into Zoom meetings or you're dragging them into your conference rooms and you're asking them pointed questions, you go to the top of the list on people that they want to pay, that they want to get rid of your cases. So why do you need this deposition? Well, we all know that State Farm calls itself the good neighbor. Literally $1 billion into that slogan. But when you get down to it and you ask the State Farm claims handlers, what does it mean when you're handling Mr. Beam's case and you're supposed to be treating him like a good neighbor? What does that mean? And the answer may surprise you.
Been with State Farm for approximately 20 years. I'm sure you've heard the phrase "like a good neighbor."
Yes.
What does that mean?
My interpretation of that is you want an insurance company to treat you just as friendly and as respectfully as a neighbor.
Now, is there any instruction or training that State Farm employees get about what "like a good neighbor" means?
I've never been involved in any training, official training for like a good neighbor.
And do you know what it's supposed to mean to the insureds, like a good neighbor?
I can't speak for the insurance. I wouldn't know how they interpret it.
The good neighbor, is that something that the employees of State Farm are bound by?
I'm not bound by it. I don't know what the other employees are bound by.
Like a good neighbor, it's meaningless. It's a slogan. It has no value at all. It doesn't mean anything to the people that are adjusting the claims. So call them out on it. What does that lead you to? That brings you to a situation where you're filing motions to get the court to compel depositions of claims handlers, of claims professionals, of the frontline adjuster and their supervisors, the folks that are making determination on the value of the claims and what claims they're going to pay and what claims they're going to pay attention to. This is a decision from a great Pennsylvania judge, Judge James Gibbons, where he compelled the testimony of a Liberty Mutual adjuster. Many times when you get these court orders and you get these depositions, you'll get to the deposition or prior to the deposition, or sometimes in a case that we're going to discuss at length, immediately after the deposition, and they pay out the claim. They turn over the policy because they don't want to fight it anymore. They realize they've made a mistake and they're in a terrible position. You can also compel corporate designates to testify. That's what the Kozarowski book was all about, and it's entitled the 30B6 book, not to be confused with his litigation obstruction book, but they both have sections in there about getting corporate designates to come to your depositions. This is just a list of cases where we have successfully moved the court for relief. Now, many of these are Pennsylvania state cases. A couple of them are federal court cases. And these cases would have application across district courts across the country. But the bottom line is, how do you get a court to talk to address in terms of a court order, deposing the adjuster? And you do it by couching it not in value. You can't ask about strategies or defenses related to value, but you can always ask about investigation. And why can you always ask the insurance company about what it did to investigate? Because facts are never privileged. Facts are never privileged. You're entitled to know what the insurance company has discovered by way of its factual investigation. And quite honestly, you'll get the court order for those depositions. Now, I talked in terms of before of what are the communications that insurance companies make that you can use in this context. And we're going to talk, as this presentation proceeds, about claims notes, claims log, codes of conduct, correspondence, filings with the insurance commissioner, websites. A lot of these themes come from the websites, the pleadings, the Unfair Insurance Practices Act, claims manuals and procedure manuals. This is the Philip Miller billboard. Philip Miller, great trial consultant. He'll break these down for you. We've got Philip active on a number of cases right now. We've used him on many cases over the years. great trial consultant, and he'll sit with you and help you prior to the big depositions in your case. This is the billboard style, and frankly, many of these precepts are right from the materials in the insurance company. Some of them are from Rick Friedman's Rules of the Road in an appendix where he talks about a bad faith case that he did. But for instance, Nationwide, first of all, the picture to the left on the screen, that's the Nationwide Way. That's the Nationwide Code of Conduct. You can have that document in your office like that. It's available on their website. It's worth pulling down, making a copy, and keeping it. And we will update it periodically so we have a sense for what changes are made. But the Nationwide Code of Conduct is an important document. In the Code of Conduct, there is unquestionably authority for that proposition, that the business of insurance is highly specialized, with policyholders vulnerable and dependent on the insurance carrier. Now, you put the Code of Conduct picture on there. When you have excellent trial consultants like we have with me today is Leah Kane. Leah runs Exhibit A. I would encourage you, and I'd ask Leah to put her contact information in the chat box. Leah can do everything from remotely and help you with all the graphics that you're going to see today. We have Leah Kane and Exhibit A on literally every single case in our office because they're that good. But when you put the Nationwide emblem and you put the Nationwide Code of Conduct and you begin asking questions, do you agree or disagree? Frankly, the answer is almost immaterial. If they agree, they should agree. And if they disagree, you can adjourn the deposition momentarily, run around the conference room desk with your arms in the air, and then sit back down and keep asking questions, because that is a precept that no qualified insurance professional should disagree with. The Allstate Global Code of Conduct from the Allstate family of companies, again, available on their websites just by a search and pressing print. There'll be a lot of information you can use in there on your Allstate cases. And again, this isn't just bad faith. I'm talking in terms of garden variety, intersectional collision, tortfeasor defendant, underinsured motorist carrier in the case. Start asking them questions from their own code of conduct that relate to investigation and other facts. But an insurance company should pay a claim unless there is a good reason not to. That's unassailable. That's black letter insurance law, and any claims professional will have to agree with that. State Farm, the State Farm Code of Conduct, immediately available on the State Farm website. The State Farm emblem on a document that you're sliding in front of a State Farm claims representative. The denial of a claim should never be based on speculation. So if you have a partial denial or you have a full denial and you're in a coverage litigation and you can tell that they haven't done the proper investigation, this is an important theme for you. The general insurance company, where we're seeing more general policies in Pennsylvania, and the general writes almost uniformly, almost strictly minimum policies. And they'll get themselves in trouble because they will jealously guard a minimum policy in cases where they should turn that over quickly. But another area of inquiry, other places where you can get communications from insurance companies are things that they file with the state insurance department. Pennsylvania, each carrier has to file a market conduct examination report, and that information can be helpful. In this Philip Miller billboard, we developed the theme that failure to fairly and reasonably investigate a claim does not permit the insurance company to deny the claim due to lack of information or one-sided information. Again, the theme of the deposition is investigation, so that concept has particular application. Safe Auto, again, filing market conduct reports in Pennsylvania. In a full or partial denial, the carrier must give written explanations pointing to the facts and policy provisions. In other words, you just can't have a blanket denial. There has to be an explanation of the basis for the denial so the insured is on notice and can contest that. The insurance company must disclose to its insureds all benefits, coverages, and time limits that may apply to the claim. Now that's from Farmers. That's the Farmers emblem. And as with regard to the insurance company's obligations to disclose to its insureds, that's not just a good idea. In the Commonwealth of Pennsylvania, that's the law. And that's the law set forth in the Unfair Insurance Practices Act. And you can cite that act and you can make that work for yourself at deposition. Here's a more practical question. Okay, the insurance company should disclose to its insured's benefits and coverages and time limits, but how do we make them do that? Well, we've developed a form letter, and which you can develop in your own state for your own practice, saying, hey, this case just came in. You're the first party carrier. You have the UIM, you have the UM, you have the first party benefits, you have the wage loss, the med pay, and tell us exactly what you have. What are the exact obligations you have to the insured? Make them answer that question. The beauty of this is you'll send that letter once, nobody will respond. You'll send it twice, nobody will respond. You go to the deposition and show them, I've been sending you letters asking you to tell me what your insured's benefits are, and you've ignored me. That's a big day in the case, and that gets everybody's attention. What about this one, Liberty Mutual? They have a very developed code of business ethics and conduct. And the precept is clear that an insurance company must fairly, reasonably, and promptly pay a claim where payment is warranted. Again, that's an unassailable concept. And when it doesn't happen, the question becomes, well, what do you do with that? Well, relative to Liberty Mutual, and frankly, in all of these cases where we've looked at these billboards, you can do this. This is Doug Lane. Doug Lane is from Detroit. When we took his deposition, he was a claims supervisor, Roman numeral 2, meaning that he had actually obtained a promotion. He'd been there about 6 months. This was a horrific case with very significant injuries. And we took Mr. Lane's deposition. We reminded him of his obligations under the Code of Business Ethics and Conduct. And Mr. Lane, who'd been there roughly 6 months, well, this is how he concluded his testimony.
Sir, are you aware that Liberty Mutual has a Code of Business Ethics and Conduct?
Yes.
Have you reviewed the Code of Business Ethics and Conduct?
Yes.
Sir, do you think based on your knowledge of the Code of Business Ethics and Conduct that I hold in my hand, do you think that your answer and claims handling in this case lived up to the code?
No.
That's game, set, and match. Mr. Lane was a ticket seller for the Detroit Pistons. I'm pretty sure he got back to the Pistons at the conclusion of that deposition. So they send these form letters, and you've seen them in your auto cases and some other cases, but they just spit them out. They're automated. I'm going to tell you something. Take a couple of adjusters' depositions, and you're going to find this to be the case. A, they don't know what the letters say. B, they don't know that there's signatures on the letters. And C, they do not review their own correspondence prior to your deposition. And I've seen it repeatedly. So you get these letters. Now, maybe this is your experience with Allstate. And if it is, please tell me. But do you really find in your Allstate cases that they have, and I'm quoting, a dedicated team of claims professionals ready to assist you during the claims process? Now, I've not encountered that, but this letter would suggest that exists. Or how about this? Allstate is working to promptly, fairly, and appropriately investigate your claim. Is that happening on your files? Because I'm not running into that. Or this, that Allstate they're just here to help. We're here to help. Or this from Safe Auto, they're monitoring your claim. So you get this letter in the beginning, you send them all the information. Here's the crash report. Here are witness statements that we've developed. Here are the medical records. Here's a vocational report. And you know what you get? 6 months later, they're monitoring. They're not doing anything. Many times this material that they're pursuing, and frankly, we just turn it over. We try to get it out the door systematically. And they're monitoring it. They're not digesting it. It's not getting analyzed in the files. They really don't know what's in their own files. So this is Bethany Johnson. She's 16 years with Allstate. She's been deposed prior to this 6 times. And Ms. Johnson's handling a case for our client, a wonderful guy by the name of Joe Cush. Joe Cush was involved in an intersectional collision, was a very significant injury. He was hospitalized, wonderful guy, $100,000 underneath him. With tort fees are at $100,000. Mr. Cush had $400,000 of coverage on underinsured. In Pennsylvania, you can stack underinsured motorist benefits. He had 4 vehicles for $100,000 each. So there's $500,000 of coverage in this case. When we took Bethany Johnson's deposition in the case, we had no offer on the case, not from the tortfeasor and not from the UIM carrier. And many times you see them play chicken. Nobody's going to make an offer. Everybody's kind of balking. So we took this deposition earlier this year in 2024. And again, Ms. Johnson sending out these letters that she does not know are going out. She did not know that she had been signing documents that say that she was going to reach a decision promptly and fairly based on an appropriate investigation. And she did not know that she was signing letters that says she's here to help. A lot of this comes as news to her.
Okay. As you sit here today under oath, are you familiar with the amount of property damage that was done to Joe Cush's vehicle?
I can certainly check, but I don't recall at this moment. No.
Okay. And as you sit here today under oath for your 5th deposition as a UIM claim specialist, in the last 16 years, do you know anything about the damage to the other vehicle, the offending vehicle?
Objection to form.
I don't.
Promptly, fairly, reasonably evaluate the claims. Doesn't know much about the file. She's still promptly, fairly, and reasonably evaluating when we ask her this question.
And in preparation for your deposition here today, as the UIM claim specialist at Allstate handling the Cush claim, did you review Joe Cush's deposition of November 2023?
Not for preparation of the deposition. No.
So think that through. This is the 6th time she's been deposed in 16 years. She knows we're coming to town to take her deposition. She doesn't review the file. She doesn't review her insured's deposition. She doesn't review her insured's wife's deposition. And at this point, early in this deposition, you've got them right where you want them. She's on video. God bless her. She's nervous. And I'm sure she's handling a bunch of files. But on the day of the deposition, this was the only one she was being deposed on. And she's got an obligation to do better than that. How about subpoenas? So you're in these cases and defense counsel, whether they're captive counsel or outside counsel, they subpoena everything, right? They use the medical, at least in Pennsylvania, a lot of medical copy services, and they subpoena every medical record, every education record, every employment record. Here's a fair question. When you get the claims handler under oath and you're allowed to ask questions about investigation, when you sent out the subpoenas in conjunction with your investigation, what did that information reveal?
So in this case, tell me what Bethany Johnson, UIM claims specialist at Allstate for 16 years, what subpoenaed records have you reviewed in your investigation?
I would need to pull them up and check. I don't know off the top of my head.
She had no idea. They'd sent out 25, 30 subpoenas. She has no idea what's in the file. She's working, of course, to a fair resolution. So I told you the facts of the case on insurance. There's 100 underneath. There's 400 at the UIM coverage with Allstate. Here's what her idea of a fair resolution is with a guy who can't work, who has a traumatic brain injury, he has spinal injuries, and he has tinnitus, and he's disabled. Here's her proposal on a fair resolution.
In conjunction with your handling of Joe Cush's claim, did you make a proposal that his damages be capped in an arbitration at between $100,000 and $150,000?
Objection.
You can answer.
I believe I had discussed exploring that option with our counsel. Yes.
Do you know that that option was raised directly to me?
Yes.
And you're aware, of course, that I immediately rejected that option on behalf of my clients, correct?
Yes.
Ma'am, is it your testimony here today under oath that went, well, strike that. Do you know how much UM/UIM coverage Joe Cush has?
Yes,
How much?
400,000.
So there's $500,000 at stake. Quite honestly, the family's entitled to every dime of that. And she's trying, in the context of a fair resolution, trying to cap his damages at $150,000. Now, please note, we didn't ask about valuation. We asked about what she extended to us by way of a fair resolution in an arbitration proposal. Here's her testimony on prompt resolution.
How much damage was done to Joe Cush's vehicle?
I'm not sure.
How much damage was done to Ms. Smith's vehicle?
I don't know.
In conjunction with your investigation of UM/UIM claims as an all-state claim specialist, do you customarily consider forces of impact?
Yes,
Do you customarily consider mechanism of injury?
yes.
Did you do that in Joe Cush's case?
I don't recall.
If you're really trying to work toward a fair and expedited and prompt resolution of your insured's claims, should you know the forces of the injury? Should you know the mechanism of the injury? Should you know that this was a direct hit on the driver's side door of a truck that drove him into a telephone pole that knocked the pole over? Should you know that both vehicles were total losses? Should you know that he had to be cut out of the vehicle by the jaws of life? You should know all those things. And if you're being deposed, one time this year and 6 times in your whole career, they should take the time to get ready for that. Having said that, it doesn't happen. I'm going to tell you something. You start taking these frontline adjuster depositions or even the supervisor's depositions in the context of these cases, they're not reviewing the materials. They're not prepared for it. And it's to your great benefit and more importantly, the benefit of your clients. This is Bethany Johnson, and I'm asking her a very simple question. What injuries has your insured sustained?
What's your understanding of Joe Cush's injuries, ma'am?
That he suffered a head injury and some spinal injuries.
What spinal injuries?
I don't know specifically. I'd have to take a look back at the records and my notes.
Did you, in preparation for your deposition here today, which I understand to be your 5th deposition in 16 years, and you stand now as an all-state UM/UIM claim specialist, did you look at Joe Cush's injuries in preparation for today?
No,
As you sit here today, ma'am, do you know whether Joe Cush suffers from a traumatic brain injury?
I don't know.
Preparation for your deposition today, as the first party UM/UIM carrier, did you look at his medical records? Did you figure out what his injuries are? No, it doesn't get a whole lot better than that. And we'll continue in a moment. Ginger, I think you wanted to take a break at 3:35, right?
Yes, sir.
Okay.
This is great. Thank you so much, Neil. We're just going to take a quick moment because I wanted all of you guys to get a chance to meet Cody Roberts with Fox AE, as well as Kyle, who's coming in with HMR today. But they're some of our wonderful partners that have been with us from the beginning. And I don't know what we would do without them. Here's Cody coming in right now. His company is so incredible because they are dealing with animations, graphics, demonstratives. They build, I mean, if you have a vision for something, they can create it. But Cody's doing an amazing job over there, and they got an incredible team. That's one of my favorite things is everyone that we get to work with over there. But Cody, thank you for joining us. I'm hoping you'll be able to share a wonderful video with us today too, to just give everybody just a little bit about what you can do.
Yeah, thanks, Ginger. And I really like your Christmas, the holiday festivities of your background. But anyway, yeah, hey, thanks for having me on. Neil, Cash, Doug, my good buddies who I get to hang out with on the conference circuit. Just
Good seeing you, Cody.
Yeah, Neil, good to seeing you, man. And Doug, man, that camera and lighting is like, I need to take some notes, man. That is professional. Satch, always good seeing you. Yeah, so we do graphics, if you don't already know. And I wanted to show you a real quick thing. We call it Fox Prime, and it's actually Amazon Prime for attorneys. And we're trying to find ways to really get the most value out of your cases. And sometimes cases don't warrant, they're not astronomical damages, or maybe there's contested liability perhaps, and we can't just fork up just huge budgets. And so you could get Mark Lanier, John Romano style graphics that are in kind of out of the box form. And so, like, for instance, this is Doug, you may have been working on with John on one of these, because I believe these were this was a CRPS case. But anyway, did you know that CRPS is actually more painful than childbirth? And that is from the McGill pain scale. But you can order these right out of the box, and pretty much whatever you can imagine. So if I just type in cervical, you can get all of the ligaments here. And even if I type in like C1, for instance, or like, let's say it's like a C2, C1, C2 level, we've got C1, C2 level disc bulges, as disc bulges are something that you can get out of the box. And so you don't have to pay, $50,000 for a really complex animation or graphic. These are coming in at $250. And so it's a way that we can help the plaintiff community and really get the best value for your buck. And we got a 50% special still going on because Ginger convinced me it was the right thing to do. So
Let me ask you, Cody, Doug here. Good to see you. What's your weather like out in the Midwest, Columbia today, Missouri?
I could walk to the Broadway Diner and get myself a stretch, Doug.
Uh-oh.
So it's
Okay.
good weather.
Now, but here's my question. We see people like Neil Cash. You mentioned John Romano, Mark Lanier, and others. How about the new lawyer, the lawyer who's trying to get his or her, I call them reps in, trying some cases, a damage model that's different than what Neil was talking about at first, multi-billion-dollar mass tort cases or that kind of thing. What can a new lawyer do to call you, and let's say she wants to add some punch to her presentation? What can you do with the out of the box, and how much more generally, how far can you go in customizing it for them?
Yeah, and we actually just did this for Philip was watching the last Connectionology webinar, and he said, "Hey, can you guys get me an injection at well, it was like S1, L1, L2, something like that." It was a custom. We gave him stock prices because it was something that is an injection that's going to be used a lot, and we can reuse that. We put it on the stock site, and then gave him the 50% discount too. And
Neil, if you have a stock image like that, can you take that to your treater and let her look at it and say, "Oh yeah, I can use this in a pre-deposition conference," and maybe if it's damage models, not a certain level. Have you ever done that, Neil, and maybe tried to do it that way? What do you suggest?
I think it's a great idea, and yes, we have done it. And Cody's stuff at A&E is great and comes across real well. So I think that's particularly for folks that are starting their own solo practice or in a partnership with a guy they went to law school with. I mean, I think it's a great way to get high quality medical graphics into evidence and help your cases.
How much does it cost, Cody, if a lawyer wants to call you and talk about her case?
We welcome it. We'll probably pay you. No, it's completely free, and we'll try to work with you based on what your case is.
Okay.
Again, a lot of people have the predisposition that graphics are $50,000 and above, and sometimes they do command that
Sure.
kind of expertise,
Right.
no doubt. But many times, especially with this Prime stuff, this Fox Prime stuff, we want to get everybody in, help them on spine cases that you may have 50 spine cases in your docket right now, and we want to help you with that in a way that helps your client.
Excellent. That helps me a lot. And I think new lawyers or the people Neil described, I think it's a wonderful thing. And thank you for doing that. And I'm looking forward to continuing working with you in 2025. Not only do we help our clients, but you're just fun to work with, Cody. Thanks.
Hey, back at you, Doug. Cash, I love you, man.
Hey, I want you to notice what's on the back of my door.
Oh, dang, yes, a little diagnostic tests.
Yeah, rapid fire TBI diagnostic test, courtesy of Cody.
Hey, that's
Nashville TBI seminar.
Mm-hmm.
I think
Yeah.
it is.
Connectionology has been so good to us. We're glad to do that for Connectionology. You guys have been, Doug and Cash and Neil, you guys, thank you so much. Kyle, you too, buddy. Can't leave Kyle out, man.
I was going to say, this is such a great lead-in because what Kyle does, he can actually help fund some of those graphics and animations, which is great. But his company, again, is also wonderful. You guys have heard us talk about HMR constantly. We're so excited to have Kyle with us today because he's going to share a little bit more about what they do and how they can help you and your clients. But this is just another great company. Just makes me smile thinking about all the people we get to work with. We're so fortunate over here at Connectionology, and thank you, Kyle, for everything that you guys have done for us.
Yeah, you bet. Thank you so much for having us. Cody, man, it's great to see you, bud. Doug, as always, it's probably been too long. I'm going to echo a lot of what Cody said. I mean, Connectionology has just been a fantastic place for our company since COVID. No pun intended, keeping everybody connected, and just made a ton of great relationships through it. So I'll kind of run everybody through, not to take up too much time. If you're not familiar with what we do, the core of our company is medical funding for people who are catastrophically injured. We've been doing this for about 15 years. We are nationwide. We do this in 40 states. And a typical case for us is somebody who's sustained, like I said, a catastrophic injury, and they are either uninsured or underinsured and can't get the treatment they need while their case is going on because they either don't have the financial resources or there's not doctors who will work on a lien. A lot of what we do around the country revolves around traumatic brain injury. We've been fortunate enough to be some of the best rehab facilities around the country. So a lot of people are coming to us saying, hey, my client's got a brain injury and they need all this care, and I've got this great life care plan, but they can't get any of the treatment. And so we kind of bring that life care plan to life and allow these people to get rehab or cognitive therapy or behavioral therapy or all the different modalities that kind of come with that. And it really kind of changes the dynamic in a lot of these cases when you can bring those things to the table. And it doesn't just stop at traumatic brain injuries. We do a lot of prosthetics cases where people have amputations. We do a lot of spinal surgery cases. We do a lot of the, everyday stuff like injections and MRIs, but most people don't need us for things like that. But as a result of doing those cases, that's how we got led to my good friend Cody. We started getting requests for people to fund the actual litigation expenses. And that can be everything from an accident reconstructionist to a demonstrative like Cody is doing, to experts to come testify live at trial. Instead of using maybe the firm's line of credit. You can utilize our resources to kind of have that firepower that you need when the defendants are, putting $100,000-$200,000 to defend their case. This gives you the ammunition to do the same. And so we launched that about 3 years ago, and it took off like a rocket ship. And so those two things combined really make up kind of the bread and butter of what HMR is about. We're not for every case, but when you get us, we really feel like you're getting somebody who's an asset to the case and to your client and to your firm. And so we've got people all over the country, so you can have a real life, like, personal experience with somebody. But yeah, that's us in a nutshell. We really love being a part of this, each week. It's been fantastic for us. So if we can help you, we'd love to.
Hey, Kyle, question.
Yes, sir.
Like I asked Cody, because we're all concerned about cost.
Sure.
One, what's your experience when the other side thinks you're undercapitalized, a plaintiff? What's your experience been with that? You mentioned that question. Second of all, is there a fee for calling you and saying, hey, Kyle, this is what I have. What can you do? And can you tailor what you do to that? And maybe they say, hey, I can't find, my client really needs to see somebody in our region. We're having trouble finding somebody. And three, values of cases. Can you help them say, hey, I had a case just like this in Kansas or in Seattle or in Florida or whatever, Pennsylvania? That's a compound question, as we say. He's objecting, but go ahead.
Yeah, no, I'll take it in pieces. I think when the perception is, when maybe the plaintiff's firm comes and they feel they're undercapitalized, it's kind of like a scab they want to pick, and they feel like they can outspend you, out expert you, and kind of intimidate the entire matter. And I think when you can step up to the table and put on the kind of case you want to put on that's in the best interest of your client, it's a different ballgame. It really is. And you talked about the young lawyer. I mean, this gives maybe some of those younger lawyers who might not, have that war chest, the ability to do some things like that. I think as far as calling us, look, we get calls every week with people going, hey, this is what I got.
Right.
There's obviously no fee for it. Really, it's kind of putting the pieces of the puzzle together. A lot of what we get, Doug, is somebody going, hey, I practice in Florida, but I've got a plaintiff who lives in Tennessee, and
Right.
they need care here, and can you help? And so I think we become more of that conduit to be able to put those pieces of the puzzle together. So in those moments, it becomes less about money and more about, hey, resources, and do you have the right fit for my clients? And so we do a good job of that week in, week out.
Hey, Kyle. Neil, good.
Go ahead.
I'm sorry, Doug, go ahead.
Yeah,
I was just going to say, Neil, those of us who in cash, we've been doing this a while. I love having different resources to talk about structured settlements, to talk about what HMR brings to the table, talk about, hey, I got this guy in Missouri who goes nationwide. He can do an animation for us, or he can do this. Don't you think that as trial lawyers, we have a duty to keep up with these things and know what's out there, Neil?
Oh, I completely agree. And not only do we have a practical duty, but in the code of ethics, of course, you have an obligation to stay proficient with technology. Kyle, can I ask you a practical question? You hit on such an important point. We represent very seriously injured people. We're developing life care plans, but then they're not funded. So at trial, the life care planner has to answer a very difficult question like, hey, you say she needs X, Y, and Z. She isn't getting any of that treatment. Talk to us about the lift that you provide the client who can get that treatment and how much better they start feeling when you fund it, and what that does to that question or that line of cross-examination at trial.
Yeah, I mean, it kind of takes the wind out of their sails when you can sit there and say, well, they've had 6 months of care in this rehab facility. I'm thinking about a specific case out of Wisconsin I worked with It was a CO case. The lady needed the care, had a $10 million life care plan, and without being able to go to the facility locally there and get some of the cognitive rehab, not only for the case, but to get her on the road to recovery, to teach the family coping skills and how to deal with the injury and what life was going to be like after, she left there, was instrumental. So I think there are these kind of light bulb moments that happen when people can get that care and they realize, hey, not only am I on the path to recovery, but again, it gives you that extra oomph in the case. And I think most people just don't know it's a resource that exists, right? They're hoping their insurance company is going to step in and cover all the care they need. And unfortunately, most insurance companies, they just, that's not what happens, and they regularly deny. So that's the feel good part of our business, Neil, is being able to help the people on the other end of it, who are really, really hurting, and their kind of life is turned upside down. So.
Well, Neil, we have a lot to cover in a little bit of time. Kyle, it's always reassuring to see you on where are you coming in from today? Where are you?
Yeah, no, I'm in New Orleans, so it's cold down here, but that's okay.
Yeah, well, when we have Ginger, I see you. I see people like Neil and Cash with Connectionology, and as you know, you've been a stalwart and supporter, which makes it possible to do a lot of these things. So thank you, Kyle, and happy holidays. And let's get back. Neil's bringing it today. I can't wait to hear how it up.
All right. Thank you so much, Kyle. And don't forget to put your information in the chat box so that way everybody can stay in touch with you. And I was just going to point out real quick a fun fact about Kyle. He's a great chef, but he also lives on this beautiful farm that I think we should all go to one day out there in Louisiana. So we'll have to go. Thanks again, Kyle.
Thanks.
All right, Neil, back to you.
Thank you. And just, Ginger, I'll make the practical observation of how helpful Kyle and Cody are in bringing this Connectionology to everyone a couple times a week, all through the year. So we appreciate all that you guys do. Thank you.
Thank you.
So we're back to Bethany Johnson at Allstate, and in the context of these depositions. No?
Good. Try it again. Take it again.
This is our client, Mr. Cush, sustained very severe injuries, and for the deposition, the first party adjuster, Ms. Johnson, doesn't really know what has happened here.
Has your investigation revealed any problems with Joe Cush's hearing as a result of the collision? You can answer.
Within the medical records, yes, as he's appearing.
In your 16 and a half years at Allstate as a UM/UIM claim specialist, have you dealt with cases where your insureds have had tinnitus?
Yes.
What is your understanding of the condition known as tinnitus?
Ringing in the ears.
Have you seen in the medical records for Mr. Cush evidence of tinnitus?
I don't recall.
Okay. As you sit here today under oath, do you know whether Joe Cush has had treatment for tinnitus?
I don't recall.
Mr. Cush, apropos to what Kyle was just talking about, Mr. Cush used a medical funding company to buy his own hearing aids because the doctors recommended he combat the tinnitus with his hearing aid, with these special hearing aids. So he funded bilateral hearing aids for himself. We sent the information to Allstate. We asked for immediate reimbursement. It never came. And at the time of her deposition, this young woman did not know that her insured was medically funding his own recovery. So it has an application in the case itself. Earlier, I mentioned the pleadings. They're very, in Pennsylvania, in state practice, they're verifying their answers to discovery. They're verifying their answer to the complaint. That's an important moment in the case. And when you get to the claims professional's deposition, hold them for downs. Show them what they've said under oath and ask them questions. Here you're going to see that Ms. Johnson has no idea what she's verified in an answer because she's taken the position that we didn't make a demand for uninsured motorist coverage and arbitration. And here's the testimony.
And you're going to say everything in this answer is true and correct to the best of your knowledge, information, and belief. Is that right?
Yes.
Okay, because it's important that Allstate file pleadings that are accurate, correct?
Yes.
Because you're trying to resolve this case and be helpful, correct?
Correct.
And you want to be fair with your insureds, correct?
Correct.
So in the answer, in the new matter, in response to plaintiff's complaint at paragraph 3, where you write, where strike that, Allstate writes, plaintiffs did not communicate any underinsured motorist claim before the filing of this lawsuit. Is that true?
Yes.
Okay. What makes you say that?
What makes her say that is she doesn't read the file. She didn't understand the file. And the next series of questions are me marking letters where we had demanded underinsured motorist coverage and told her that she had an underinsured motorist claim. This is a case where we had, at the time of the injury, a significant injury, and Mr. Cush applied for Social Security disability. In the context of that Social Security disability application, there was an evaluation. The evaluation by an independent examiner in the Social Security context came back entirely favorable to Joe Cush. This adjuster, Ms. Johnson, didn't know that. Now, how should I be able to how could I take the position, well, you should know that? I sent it to her. I sent her the evaluation. I sent her the successful determination from Social Security that Michael O'Donnell does a great job on everything he touches in this office, that he prosecuted for us, and he got the Social Security result. It's in the file. I have it marked. I'm ready to go. She didn't know it was there. And here's what that looks like at a deposition.
T1 fracture. Have I read that correctly?
Yes.
Number 6, cervical radiculopathy. Have I read that correctly?
Yeah.
Prognosis. You see the prognosis highlighted at the next to last paragraph?
Yeah.
What's the prognosis for Joe Cush as a result of Dr. Stone's disability evaluation?
4.
Okay, so when you offer a $150,000 cap on Joe Cush's arbitration, you didn't have this document, did you, ma'am?
I don't recall ever seeing it. No.
Okay. This is the type of thing that is of great significance in your investigation into this claim, isn't it?
Objection, cause for opinions, instruct the witness not to answer.
So that's an interesting point. She had the document because we'd provided to her. She didn't review the document. They have a great lawyer in Pennsylvania representing this witness, especially retained because they don't like to get their claims professionals deposed. So many times you'll have the Allstate lawyer, then you'll have the potential bad faith lawyer, and then you'll have the independent counsel for the witness or the claims professional. And the reason I clip that is there's a great lawyer making just basically saying, throwing in the towel, right? He's instructing her not to answer. Like, would you like to know that there was an independent disability determination and it found that your insured had a T1 fracture, cervical radiculopathy with tinnitus that required paid hearing aids that he paid for? Is that something you should need to know? So you get the message that this poor woman is down for the count. So this is Tony Vicia. She is an adjuster at USAA, and these are strict Rick Friedman rules of the road right here. Rules of the road. I want you to see how swimmingly we're doing until we get to the question about should you really be using biased experts against your own insureds.
Sir.
Can we agree that the business of insurance is highly specialized, with insureds particularly vulnerable and dependent on their insurance company?
Yes, sir.
Can we agree that a company should pay an insured's claim unless there is a good reason not to?
Yes, sir.
Can we agree that USAA must fairly and reasonably and promptly pay claims when payment is warranted?
Yes, sir.
Can we agree that a failure to fairly and reasonably investigate a claim does not allow USAA to deny the claim?
Yes, sir.
Can we agree that USAA recognizes that it is not appropriate to use biased consultants to assist in the investigation or evaluation of its insured's claims?
I'm not sure I understand.
Let me repeat the question. Can we agree that USAA cannot use biased consultants to investigate or evaluate an insured's claims?
I'm not sure when you say biased consultants
Would you-
specifically they're referring to.
Which part of the question don't you understand?
What you're referring to when you say biased consultants.
She knows she has biased consultants in the case. She doesn't want to answer that question because it's going to make for a longer day. But we go on a little bit with Ms. Visia and ask her about the purposes of logs. Now, why would we be doing this? Because hopefully when you take these depositions, you'll have the logs. I used to be a strong proponent of never taking a claims handler's deposition without the logs. I've kind of come off of that because we developed a way to handle it. But for purposes of this deposition, I wanted to point out to her that she was acting in a way that wasn't consistent with the log information. But first you have to establish why they need logs.
Why is it important to properly keep the claims notes in a file?
Well, it's important to know what is going on with the claim, what documents are provided, what items to consider, and any information that's discovered or learned throughout the investigation of an entire claim.
And is that important? Is that information important so anyone working on the file can pull up your claims notes and see where the case is?
That is correct.
And that would include your supervisor?
Yes, sir.
And
So you put it in a form of a question where you basically tell her what the purpose of the logs are, because you're making a point that you're sending information, you're sending medical records, you're sending reports that you've developed, you're sending independent witness statements, but she's not logging it. It's not in the logs. And the fact that it's not in the logs is better than having it in the logs, because when you're asking for a supervisor to review or when you're demanding a policy limits tender, they don't have the information in the logs that's in the file. So it's a great point for you during these claims adjuster depositions. This is a woman, she is Tayeti Williams. She's with Progressive in just in the suburbs of Philadelphia. These are the folks that are handling your clients' cases, injured people that you'd like to be able to think, I have a shot at resolving this case at the claims level. I'm here to tell you, you don't. You don't really have a shot at resolving most of these claims at the claims level because of things like this.
do you have in-house training at Progressive?
Not that I'm aware of.
Okay. Did you have any in-house training at Lincoln?
No.
Did you have any in-house training at Penn National?
No.
Any in-house training at Harleysville?
No.
And no in-house training at Progressive?
No.
Okay. Is it fair to say that all of your insurance training has been on-the-job training?
Correct.
Do you know what the term CIC stands for in conjunction with insurance?
No.
No CIC, no CPCU, no training, no real education. It's OJT, right? On the job training. So she's learning from somebody who doesn't know what she's doing, and it just perpetuates itself. So you're sending the medical information, they're tossing it in the file. They scan it into the file. It's not being reviewed. You never really have a chance. You never really have a chance for a fair evaluation until you place the case into suit, in my view. And once you place the case into suit, then you get a shot at the deposition of the claims handler. And what documents are you looking for? You're looking for the claims file. You're looking for the details on the decision, what was made, when it was made, the investigation. Get a chronology of the insurer's handling of the investigation of your claim. When you have the file, mark the file, the whole file as an exhibit. There'll be redactions. You can fight over the redactions at some point. You can certainly ask for a privilege log on what's being redacted. But once you mark that file, I guarantee you they're going to tell you things in the file that they don't know they've told you. And I guarantee you when you sit with the file and a cup of coffee in a quiet room and you review the claims log, you'll know the case better than the adjuster will. Again, policyholder perspective, the deposition of the claims handler, documents to review prior to the deposition, the scope of the testimony, the policy documents, the claims itself, the claims handling manuals and procedures. And if you can get those through discovery, great. If you can get those through some other means, the power of these listservs, these practice groups, Connectionology included, everybody has materials, and sharing that material is important. And if you can do it and there's been no confidentiality stipulation, I have no problem producing anything we have in the office that we've discovered in our cases. There are, of course, in all of our practices, ethical considerations. 3.3, candor to the tribunal. 3.4, fairness to opposing party and counsel. These are, by definition, adversarial proceedings, but adversarial within the context of being a professional. Follow the code of civility. Shake hands at the beginning, shake hands at the end. Give it your best shot during the deposition itself. Always maintain your obligations under the code of civility. A lot of seminars on Connectionology and national trial lawyers, which Doug will take over in January, discussing these techniques of boxing, exhaustion, bracketing, cementing. What more can you tell me about that? What more? Tell me more. Empty them out. Make sure you've got all of the answers. So I talked before about it's preferable to have the claims log. We didn't have the claims log for Ms. Johnson's deposition. And I knew I didn't have the claims log, and I knew she would likely review it. So how do you handle that at the deposition? I recommend this technique.
Ms. Johnson, what have you reviewed in preparation for your deposition today?
Just the discovery that Terry Barone, on behalf of Allstate, has produced to you. And I took a brief look at the claims notes.
Have you produced the claims notes to me?
It's my understanding from Terry that they have not been produced.
Okay. Do you know why they haven't been produced?
I do not.
Okay. I'm going to ask you to produce the claims notes, and I'm going to adjourn rather than conclude this deposition, okay?
Okay.
So at the conclusion of this deposition today, I will ask that the claims notes be provided to me, and I reserve the right to bring you back, so I will not conclude the deposition, but I will adjourn it. Fair enough?
Yes.
How delightfully she received that news that we may get to do this again. This deposition, by the way, was about 90 minutes. And when you go in and you have your exhibits marked and you're dialed in, 90 minutes is enough. And you make your point in 90 minutes. By the way, this case settled and paid out within 48 hours of this deposition. And this young woman had excellent counsel, and she knew at the conclusion of the deposition that she had a problem brewing, and they paid out the claim at both levels. But when you don't have the claims log and you have a lot of other ammunition, go ahead with the deposition. Tell them you're going to bring them back when you have the claims log. And don't conclude the deposition, but continue it or adjourn it to another date. So qualifications matter. You'd be amazed. These frontline claims handlers, these supervisors, they just don't have any real training.
Ms. Johnson, are you a CPCU?
I don't know what that is. So
okay. It's a specialty designation in insurance, but you don't hold that designation, do you?
I do not.
Are you a CIC, a certified insurance counselor?
No.
instructions not to answer. I don't think I'm unique when I say this, that we are encountering more of this. And I think we should actually be encountering less or none of it. But when you really drill down on the instruction not to answer in federal and state practice, it is a very dramatic objection and a very dramatic remedy that can only be used in certain cases, in certain instances. For instance, privilege, or to enforce a prior order, or to make a motion on privilege. But there are a lot of lawyers that think, I don't like the answer that's going to come to this question, so now I'm free to instruct the witness not to answer. That is not how the instructions work under 30C2. That's not how the instructions work under Pennsylvania state practice or federal practice. And you can't leave that lie. So if it's an important point, and frankly, when you're getting an instruction not to answer, 95% of the time, the testimony is devastatingly in your favor. So you've got to follow up on that, even if it's just one. And instructions not to answer are like potato chips. They don't just come in groups of one. There's always a bunch of those. So this is a case that was a very significant matter in Lackawanna County, northeastern Pennsylvania, Scranton, where a great judge, Judge Robert Mazzoni, brought a doctor back to answer questions, and there were 59 instructions not to answer. What the court really based its analysis on was that the deposition was taken pursuant to the usual stipulations. So you know how that goes. Everybody sits down, usual stipulations, yes. And in this context, usual stipulations was determined by the court to mean that all objections except to the form of the question would be reserved until trial. So it shows you that those mechanics at the beginning of the deposition are very important. And if witnesses are taking depositions according to the usual stipulations, that is a real strong argument as why are they instructing this guy not to answer? It's not privileged. There's no court order. And it's something to consider when you're fighting over instructions not to answer. This gentleman was at the time the statewide supervisor in the Commonwealth of Pennsylvania for State Farm's underinsured and underinsured motorist division. So it took us a court order or two to get him to his deposition. But then again, he in that powerful position, he's the guy in the Commonwealth of Pennsylvania on underinsured and uninsured motorist litigation claims. And we're sending him records, and you can hear it for yourself.
Mr. Firth, in conjunction with your ongoing investigation into this claim, have you reviewed the report of Richard Fishbein, MD?
I'm aware of it. I didn't really read it. I'm aware of it.
You didn't read it?
I didn't read the whole report.
Did you read any of it?
I read some of it. I don't really recall. I know he's a psychologist. Psychologist.
If I were to inform you that Dr. Fishbein is a board-certified forensic psychiatrist, does that refresh your recollection as to whether you've read his report?
I'm familiar with the name.
Are you familiar with his findings concerning State Farm's insured Lorraine Polowitz?
I can't recall.
This isn't the third-party adjuster, right? This is the first-party adjuster. This is the uninsured motorist carrier, the underinsured motorist carrier, the first-party benefits carrier. They're getting information. They're asking for information. Nobody's reading this stuff. They don't have any idea what it is. And he comes to his deposition in that high position. His lawyer invokes 54 instructions not to answer. Now, you've got to go to battle on that. You have to be the man or woman in the case that does what you say you're going to do. And when they start instructing not to answer, make a record and say, I'm going to bring you back. I'm going to make them pay for it. And I'm going to ask you these questions again. And here we're back. And there's Mr. Firth again, after a court ordered him to answer 50 of the 54 questions. And he talks a little bit about how he's advocating in the case.
Is it your testimony here today that what we're witnessing is your advocacy on behalf of Lorraine Polowitz as you handle this claim?
I'm still handling her claim, yeah.
Are you advocating on her behalf?
Well, Yeah, I am advocating on her behalf.
And you're using your best efforts in that advocacy, is that correct?
I am.
And as Lorraine Polowitz's advocate, you're advocating at State Farm for her. Is that your testimony?
I'm advocating as her underinsured motorist rep.
And you advocate to representatives at State Farm, correct?
Advocate to what?
To your supervisors at State Farm?
What?
Well, who are you advocating to?
I'm an advocate for Lorraine Polowitz's claim for underinsured motorist coverage.
And to whom is that advocacy directed?
It will be directed to Lorraine and her counsel.
And you're advocating with me?
Sure.
Okay. Well, what are you advocating with me?
I'm advocating the fact that I agree with you that Lorraine's not at fault for her accident.
Okay. How about on the damages end? You're an advocate for Lorraine on damages as well?
Well, I think we finally reached the, I think discovery's been concluded, so I haven't reached a final decision on damages.
You're going to direct your damages advocacy to me?
Eventually, yeah.
Would you tell me what you're going to do to advocate?
He's advocating for his insured. To me, this should be the shortest advocacy proceeding in litigation history. But he's just saying words. And he got stuck in the deposition. That case paid promptly after his second deposition. Sometimes when you're looking for the claims log, they'll make a distinction. Well, we'll give you the log before litigation was instituted, but not after litigation was instituted. That is a distinction without difference. We have a number of decisions where the court said there's no difference. He's entitled to the claims log because that's your insured. And this was a decision from Lackawanna County that said you're making a distinction between post-suit and pre-suit, and that is not going to carry the day. Claims log is important. These are some decisions from Pennsylvania state courts obtaining the claims log in this kind of litigation. That's been held up in Luzerne, Lackawanna, Philadelphia, counties across the Commonwealth of Pennsylvania. So this is Tim Caslin. At the time of this deposition, Mr. Caslin was with Motorist Mutual Insurance Company, and I note the objections during the testimony because I think this is the easiest way to deal with them. And when you're taking the adjuster's deposition, in the world of the insurance defense lawyer, you're deposing their client. So they immediately know that the guy's underprepared. They become very sensitive to that, and you get a lot of objections. And here's how I would recommend you handle those.
How many times have you and I communicated concerning the Marion claim?
Objection, time period, before suit, after suit.
Objections noted. Do you understand my question?
I do.
You can answer it.
I can't give you a number of times we corresponded about the matter.
Would you agree with me that I sent you letters at regular intervals?
Yes.
Would you agree with me that I sent you medical records?
Yes.
Okay. You're aware that the date of the collision was July 30 of 2011, correct?
I am.
Would you agree with me that's 502 days ago?
I wouldn't know the number of days that is, but I'll trust that's correct.
Okay. Look into the camera and tell us, please, in 502 days, since all of the information that's been sent on this claim, what settlement offer has been extended to Amanda Marion?
We have not extended a settlement offer on Amanda Marion.
Not one dime, correct?
Correct.
Okay. Lot accomplished in that little clip. First of all, the objection. Give it completely the back of your hand. Okay. Objections noted, you can answer. Secondly, did I send you medical records? Yes. Did I send you witness statements? Yes. Have I sent you expert reports? Yes. Why would you ask that? Because you want to get credit for it, right? Your office has done the hard work of keeping this guy up to speed. And in 500 days, despite the fact that 500 days have passed, he's had all that information. They haven't offered one dime on the case, not one dime. By the way, in my view, that is deposition of a party opponent, of a corporate representative, of a person in authority on that claim. I think you can get that clip in direct evidence into your case in chief. Here's prompt evaluations.
Objective and prompt and reasonable investigation of this claim. Has anyone at Motorist Mutual reviewed Sean Hannahue's report of November 20, 2012?
That's a question I don't know the answer to. I don't know if anyone has.
In conjunction with Motorist Mutual's prompt, thorough, and objective, and reasonable investigation of this claim, has anyone at Motorist Mutual reviewed the neuropsychological evaluation of Dr. John Harvey completed in March of 2012?
I don't have that information.
To your knowledge,
To
no
my
one?
knowledge, no.
This woman had enormous injuries, and this was a corporate policy through her family's business. 500 days. We just talked about a vocational report, an economics report, and the treating neurologist and neuropsychologist, and nobody's offering her a dime. And the liability piece is not at all in dispute, as you'll see in a moment. Here's some witness statements.
When Ms. Marion stops and confronts Ms. Lakaitis, she writes, quote, Ms. Lakaitis screamed obscenities at me. She said, "Fuck you," repeatedly. I felt so violated. I told her that the police would be there momentarily, and she responded with a sarcastic remark about them taking away her children. Where was the remorse? Have I read that correctly, sir?
Yes.
Sir, as an 18 years in your business, and now 18 months at Motorist Mutual, when you read this type of statement, would you regard it as emotional?
Yes.
Would you regard this as an unusual occurrence?
Yes.
Could you see that this is the type of occurrence that could cause some psychological or psychiatric overlay?
Perhaps, yes.
The single mom that has children in the car, she gets creamed by a drunk driver who comes out and assaults the mom, comes right up to the mom and gets into it with her. And these folks have all this information and they haven't offered any money on the case. It's unimaginable. But here's the main point. You take these depositions on your schedule, right? You take these depositions after you've loaded them up with all the information. They've got all your whole investigation. They have the criminal file. They've got all of the expert reports, and then you're ready to go. And that is what a disastrous deposition looks like.
My question to you stands. 14 months, 15 months post-collision. Is it consistent with reasonable and prompt and objective and thorough claims investigation for the insured to be asking Motorist Mutual to take examinations under oath and to conduct medical examinations?
Well,
is that consistent?
I'm not privy to what happens in that discovery process from the time that litigation's filed.
You're privy to this letter, and that's what I'm asking you about.
I'm privy to it now.
Yeah,
so
that's what I mean.
if you're asking about the promptness of things that occurred in the discovery process prior to this, I can't characterize it because I'm not involved in it.
But you have told me earlier that Motorist Mutual can't stick its head in the sand when it assigns the matter to litigation counsel, correct?
Yes, I mean, that's,
and sir, 502 days later, still no examinations under oath, no recorded statements, no medical examinations, correct?
Correct.
Nothing further.
Motorist Mutual has obligations to its insureds, like every insurance company. I hope you picked up on the fact that we're asking them, would you please send our client for an independent medical examination? We're asking them, would you please sit down and take our client's examination under oath? You have all of the information. By the way, that line about an insurance company can't stick its head in the sand, that is directly from some of the leading bad faith cases in the Commonwealth of Pennsylvania. So when you're saying that to these adjusters, you're talking their language. And they know what's next after 502 days and no offer on a case like that. So here's just a couple of other Pennsylvania-based decisions on obtaining the claims log. I'm running a little bit late here. I do want to play this for a couple of points. First of all, it shows you how far Leah Kane and Exhibit A have brought our practice on video depositions. This looks like a lunar landing, this particular video. But this is Chris Perret in a case involving a police officer who kept saying that he couldn't get the records out of underwriting. I want you to hear this.
Where's underwriting located, Mr. Perret?
In the same building, they're on the same floor.
How long would it take you to walk from your desk into the underwriting office?
Less than a minute.
Okay. Prior to February 23 of 2009, when you had questions concerning the availability of underinsured coverage for Captain Tom Bradley, did you ever take that minute walk?
No.
Okay. Did you ever go to underwriting about it?
No.
Should you have?
In retrospect, probably.
Particularly when you were raising questions about the availability of the coverage, correct?
Yes.
You were down there and had these questions answered in a couple of minutes?
Yes.
He didn't walk 30 feet from his cubicle to the underwriting cubicle. He just kept denying the claims and saying that I can't process this. We don't have the appropriate documents. You, meaning us, you have to go to underwriting. And this is a decorated police officer that was in a severe collision and sustained, quite honestly, very significant injuries. Here's our friend Teddy Williams from southeastern PA, Philadelphia suburbs, and she's with Progressive Insurance. Remember, all of her training is OJT, on the job. Oh, I'm sorry. I got it. Let's see here.
Medications now include Xanaflex, Neurontin, Norco. Have I read that correctly?
Yeah.
Do you know what Neurontin is?
No.
Do you know what Norco is?
No.
Do you know what Xanaflex is?
I'm not sure.
Do you know whether Neurontin or Norco is a narcotic pain medication?
I do not.
Is that the type of thing you should know in conjunction with your investigation of Heather McTagg's underinsured motorist claim?
Objection to form.
I typically, if I don't know of any medication, I'll look it up on Google.
Do you know whether you Googled any of these medications?
Not that I recall.
Handling her clients, her insurance claims. None of the medications are familiar to her. She didn't even bother to Google it. I remember vividly, we played that clip for the trial judge, and he literally just shook his head and said out loud, you have to do better than this. Last point I'll make is Pennsylvania has a great Unfair Insurance Practices Act. I hope your state has a similar act. And in Pennsylvania, it's an unfair insurance practice to fail to provide a reasonable explanation of the basis for a compromise settlement offer. Well, what does that mean in practice? That means you get this, you have a great case. You're peppering the file. You're making sure they're totally up to speed on the nature of your case and the severity of your client's injuries, and that liability is not in question. And then the big windup and Nationwide on your side offers $1,500. What do you do with that? You take your state's Unfair Insurance Practices Act, you make it into a form letter, and you say, oh, thank you very much for your $1,500 or your $5,000 settlement offer. I'm going to meet with my client, but would you do me a favor? Would you break that baby down for me? So you can tell me what I can explain to him or her, how you got to $1,500 or $5,000. That works. I've run a little bit over. I appreciate your time. Thank you very much.
Neil, thank you so much. I do have a question, Neil. The pacing of your questions, can you just tell us the logistics of how you do it? Prepare for your depo, marking your exhibits, pacing the questions. They tried to throw you off on one objection, and you simply said, objection noted, and kept going. Speaking objections, you seem to handle that. I don't like standard stipulations. I don't like that. Can you just tell us, because you're very effective. You're polite, but you're no nonsense. Is that?
Well,
tell me how you do it.
It's thank you for saying that, Doug. It's very kind of you. I think the more depositions you take, the better you get. And I don't have any original thoughts. Everything I do, I've stolen from somebody, and I probably have stolen things. I know I've stolen things from you guys and probably some of the people that are watching, but come out swinging. I don't care where you went to high school. I don't care what your favorite ice cream is, but I want to know, I'm going to take the worst thing in the case for you. I'm going to ask you your name, and then I'm going to hit you with the worst thing in your case. And we're going to go from there. And then I really do try to be organized according to the exhibits. And I really think 90 minutes is a perfect deposition time, maybe 2 hours. Now, there are times when you can't do that because you're fighting or there's calling the judge and that type of thing. But I think the more prepared you are, the shorter your deposition can be. Don't overreact to their objections. Objections noted, you can answer. You understand my question, you can answer. And one of the great responses to objections that I've liberated from our friend Mark Kozarowski is on speaking objections. Don't make suggestive comments in front of the witness. Now you can answer. And it makes a nice little record for you if you do find yourself in front of the judge.
Cash, what do you think? This has been really enlightening, hasn't it?
No, it has. One of the things that learned recently, I'm embarrassed to say, is that last letter, when you send that last letter out, said you've offered 1,500. Hopefully it's more like you've offered 100,000. The policy is 500,000. Add another sentence. Since you agree the case is worth at least 100,000, send us your check for that amount within 10 days.
And you'll get, that's a great idea, Cash, and you'll get that because they're going to regard that as undisputed policy proceeds. State Farm will do that. Liberty Mutual will do that. That's a great tip.
Why, Neil, do they not prepare their people more?
I think the adjusters feel overworked. You know, come hell or high water, their day is going to end at 4 o'clock, and they don't see themselves going home to prepare for your deposition. And at the end of the day, when you know they've had a bad deposition, they swoop in, pay it, try to make everything right. They feel that they've lived to fight another day. That same witness will be equally unprepared the next time. And for this, we are thankful.
Well, we're thankful that you made time for the final Connectionology of 2024. I'm honored to appear today with you and Cash and I to moderate. Neil, you are a stalwart. And Ginger, what do we have to wrap it up here in 2024?
I know, I'm actually kind of a little bit sad. I know we only have like 2 weeks and then we'll start rolling out the new webinars. But you guys, we're not joking around when we say the minute we get back on January 2nd, we've got another webinar planned. And we were actually bringing John Romano's coming back. So I think we have a full schedule for January, for March, even February. And so I'm just going to be working like the next few days to kind of get those out as soon as possible so you can save them on your calendar. But we have a lot of great things coming up. And also, please definitely think about coming to our Idaho TBI seminar. It's going to be our 4th annual. We've decided to move from Nashville to go to this beautiful lodge out in the mountains, and it's going to be a lot of fun. The agenda should be ready hopefully by Christmas, hopefully sometime next week. We'll have something that we can put up on our website so you guys can take a peek at that. But just keep your eyes out for that. It's going to be May 8th through the 10th. And then, of course, I just got word today that we're going to be doing our 3rd annual Depositions Are Trial seminar. Neil, this is a perfect, just lead in, getting everybody excited about depositions by doing this today. But we'll be doing that again next November. So lots of great things happening next year. And I just want to thank everybody so much for supporting us here at Connectionology, for spreading the word. That's the best thing you could do, is tell a friend or a colleague about the company so they can also watch the webinars and learn a lot from people like Neil and Doug and Cash. But I can't wait for next year. So thank you so much. And as you guys know, we cannot end this webinar without having Ted pop in, because he's here to share good news for one lucky winner who's going to win 2 bags of this new coffee that he has. It's a special Costa Rican coffee, and there's a special mug that you're also going to get so you can drink your coffee with it. But Ted, we're glad to have you with us.
Yeah, well, it's great to be with you on the last webinar of the year. So it was great to listen to this one with Neil and Cash and Doug. It's been too long, so it's always great to see you. Yeah, I'm excited to say it's Michael Goldberg out of Ohio is our winner of some great coffee. It's Costa Rican Terrazzo. So it's always fun to say these fancy names, but I've tried it. It's wonderful. We just got it in, so I'm really excited for everyone to enjoy it. So congratulations, Michael. And
Ted, I know all is right in the world when I see you. It's just so reassuring. We have these great webinars rather, and at the end of it, I can always see Ted, and it's just reassuring. I don't know. It's just one of those things in life. it's a tradition. So I appreciate all you do, Ted, and you're
Excellent.
always a gentleman. And I just love talking with you at the conferences and in between about cases. And but thank you for what you do. It's just it's nice. It's one of those things in life that it's just nice.
And you know what I think the best part is, Doug, is that we are all going to be there with you in January at the Miami National Trialers Conference, where we get to watch you become the president, which is very exciting. And HMR is actually going to be holding an after dark party in your honor, right, Ted?
Yes, yes. So come on the 27th to Hyde Beach and celebrate Doug's inauguration as president. So it's going to be a fantastic time.
Well, thank you. I'm honored and humbled to be selected, and it's just to have my peers that have become friends and colleagues, and they help me help my clients. So it's just quite an honor. So I appreciate everything. Thanks.
Yeah, I'm sure. Yeah.
Person. It's going to be awesome, Doug. And thank you so much. I hope you guys all know we're very grateful and thankful for each of you.
Yeah.
And again, Neil, this is a great presentation. Already looking forward to having you back very soon. And last but not least, you have your grandfather now, but please tell us a little bit about your beautiful grandson.
Thank you. He's 27 months old. We share a birthday, and his name is Adam Rashid O'Donnell. He's the son of our son Neil Philip O'Donnell and Mahek Rashid. So just very proud of them, and he's a beautiful little boy. Very kind of you. And Ginger, the last thing I'd like to say, I'd like to thank Leah Kane from Exhibit A. Not only does she help me get the PowerPoint, but she sits here and makes sure everything works on our end. And I asked Leah to put her information in the chat, and I know she's done that.
Oh, please do. And quick question about Leah, because I did want to ask, I know she can work with other attorneys around the country remotely on some of these depositions, but she can also travel too, couldn't she?
Oh, yeah. Leah goes. She does whatever. They have a statewide firm, and Exhibit A does whatever is needed. And Leah, why don't you address what you guys do?
Sure. I'm off camera here on the side, so I apologize, but maybe we can swing that a little bit. Thanks, folks. My name is Leah Kane. I'm a principal with Exhibit A. We are a trial technology firm. We started out bringing, computer equipment into the courtroom to display evidence to the jury. But now I would say 85, maybe 90% of our work is in the creation of settlement videos for our clients. And Neil has been a longtime client of ours. We go to the courtroom with him. We go to the conference room with him. We go to depositions with him. So I'm very grateful to be with him today and always. And it's been a pleasure working with you all today.
Absolutely.
for having me.
I'll make sure that I add your information so everyone can stay in touch with you and
Thanks,
reach out as
Ginger.
well.
Thanks so
because
much, Ginger.
you make this flawless and we love working with you too.
Thank you. It's been a pleasure.
All right, everybody. Happy holidays. Seek justice. And we'll see you in 2025.
Absolutely. Merry Christmas. Happy holidays.
Merry
We love you
Christmas,
guys.
Merry
everybody.
Christmas.
Happy holidays.
Bye-bye.
Bye-bye.